All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order.
All right, good morning and welcome to the District of Columbia Court of Appeals oral arguments, which we are conducting via the Zoom government platform in light of the COVID-19 pandemic and for safety reasons. Our cases today are now just two cases. One case has settled. The first case this morning will be DASEAN Matthews versus United States. Are the parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Great. Appellant?
All right, Mayor. Good morning, Your Honors. May it please the court, James Whitehead on behalf of Appellant DASEAN Matthews. I'd like to reserve 2 minutes for rebuttal. I wanted to emphasize 3 points this morning. First, the testimony of the crotch adjustment described in the motion was so vague and ambiguous that it does not contribute to reasonable articulable suspicion. Second, that Mr. Matthews' flight from officers was not indicative of consciousness of guilt because it was prompted by the police. And as in Miles, Mr. Matthews' flight was not unprovoked to the same extent as the defendant's flight in Wardlow. The evidence here is that when the police slowly drove by Mr. Matthews and made eye contact with him through the car's open window, Mr. Matthews asked the officers, "What the F do you want?" as they went by. He adjusted his crotch in an open and obvious way, and he did not run at first glance. Rather than continue on their way, as one may hope, the officers stopped their car in the middle of the one-way street, put the car in reverse, reversed back to Mr. Matthews' position, and Joshua Wilson got out of the car to confront Mr. Matthews. And only at that point did he flee. And at that instance, considering the officer's tactics in confronting Mr. Matthews, those actions, to quote Miles, would be startling and possibly
Mr. White, could I interject briefly? The briefs and supporting documentation spend a lot of time talking about crotch adjustments. And is your argument that crotch adjustments are never furtive gestures, or that this crotch adjustment viewed as the officer described it was not a furtive gesture?
No, it's that this crotch adjustment was not a furtive gesture, and there are just too many innocent explanations.
Why was this one different from other crotch adjustments, which our cases have cited to a number of times because of suspected, under certain circumstances, concealment of drugs or weapons and that?
That's right. So the court has to look to whether or not the behavior, as testified to, the evidence, there's objective, particularized evidence that bridges the logical gap between that behavior and reasonable suspicion. And this court in May talked about gap fillers. And the evidence simply does not have any gap fillers between the sight of seeing Mr. Matthews just grab his groin and pull up a little bit and indication that he was armed or had contraband in any way. First, there was no bulge, which the case law has talked about over and over again, whether it's RMC or in even cases that there are bulges doesn't necessarily mean that there is reasonable articulable suspicion. But there's no bulge, no outline of a gun. There were no hand gestures that were so peculiar as to suggest that he was harboring some type of something illegal. There was no response to any type of criminal activity. There was no allegation that Mr. Matthews was involved in any criminal activity or was carrying a weapon. There was no informant tip that the police were following up on. And there was no indication that he was trying to conceal or shield his hand motions from the officers. So his entire actions were open and obvious to the police.
Well, except when you, if you look at the testimony at the suppression hearing, the other factors that the trial judge credited, perhaps if we only had the crotch adjustment, or if we only had the high crime area, or only had the flight, there is, I think, a stronger argument that maybe these are just innocent gestures viewed in isolation. But when you combine them, we have the totality of the testimony that we have here. Does that allow us to view these individual discrete actions any differently under our standard of review?
No, and in fact, looking at the totality of all the circumstances here, under a kind of a realistic and earthy point of view and perspective.
Earthy?
Well,
I'm just teasing him.
I just want to quote the court. But if you 0 plus 0 plus 0 equals 0, and that's what we have in this case, because we have this.
But if that were true, then what does totality of the circumstances mean?
Well, totality means that if there's indicia, that there might be indicia that could suggest it in some cases that turn an innocent seeming gesture and elevate it into something that would create reasonable articulable suspicion. But in this case, especially with the context of the not unprovoked flight, to quote Miles, there's no elevation of the crotch adjustment, again, with no bulge or the other gap fillers or indicia of on its own to show that there is a weapon or some type of contraband involved. If we look at the context, the police officers slowly drive by, they make eye contact with Mr. Matthews. And at that point, there's a distinct flavor within the testimony and the evidence that this is not going to be a positive experience, that this isn't Mayberry where Andy Griffith is officer friendly, or this is going to be a harmless Barney Fife situation. There's an acknowledgement between the two parties, Mr. Matthews and the officers, between the eye contact, and then Mr. Matthews makes a statement. What the F do you want? And that's on page 88 of the July 30 transcript. And at that point, the officers testify and they say that there's this adjustment that takes place, and they drive off. Mr. Matthews has not fled. This is not similar to Wardlow with the pure sight, mere sight or noticing of police officers passing by. Did he break out? He actually drew attention to himself by making a crude or rude statement to the police and then adjusting his crotch in a way that—
Where in your chronology do we get to he separates himself from the group somewhat? That's part of what's described in the briefs.
No, that's also correct. So this takes place, and it's a little bit unclear. I have to check back, but it is definitely before the officers go in reverse. I mean, I think it's one of those factors that even the trial court itself did not take into account or consider as material to its decision. So the fact that he separated himself a little bit, and even Desna Lee said that he separated himself as they were all trying to not deal with the police. But he separated himself before they went into reverse. Now, either way, that he still draws attention to himself by making a statement, what the F do you want? And at that point, probably hopeful that the police continue on their way and don't try to engage in any way. But the police essentially call his bluff. So they, instead of pulling over to park in a natural parking spot, to give the appearance of at least some type of non-hostile encounter, instead, the police stopped their car in the middle of the street, a one-way street. This isn't 3 o'clock in the afternoon. There's traffic. This is a busy place. Stop the car in the middle of the street, go into reverse to where Mr. Matthews is standing. And you could tell that the officers are going to confront him because you could see Joshua Wilson's hand on the door handle as Officer Hyder is going in reverse. And he immediately jumps out of the car and gets out of the car, again, in the middle of the street. Now, anybody in that position, in Mr. Matthews' position, reasonably could be in fear and apprehensive about what the police are going to do at that point.
Doesn't he start to run before the officer starts to get out of the car?
No, I don't believe that's right. I think it's and I'll check with the testimony really quickly, but that it's pretty much simultaneously. As the officer is getting out of the car, that's when Mr. Matthews runs.
Why is, what do you, how do you define the notion of provocation? It seems to me you're taking the strong position that this was a provoked flight, and therefore it does not carry with it the connotation of suspicion that it otherwise would. I have trouble seeing that it is provoked, but a lot depends on what we mean by provoked. How do you, could you justify calling this provoked?
Well, at first, I just want to kind of put it the framework here, because I think that's why I led with Miles and the way that this court described the flight and taking into consideration for consciousness of guilt into account was that the flight was not unprovoked to the same extent as the defendant's flight in Wardlow. So Wardlow is the barometer for which we examine flight. And that's why this court—
But why should that be true? I mean, police officers are entitled to approach individuals to seek to talk to them. This is in broad daylight. Appellant is not alone. He's with other people. The officers come up, they see him. He has said something to them. The officer wants to talk to him. The officer drives back towards him. I don't see that. I don't know that one should view that as provocation. I'll put it to you that when I think of what should constitute provocation in this context, I don't know that there's a lot of law on the subject or clarification. My thinking is that provocation ought to be the kind of behavior that objectively would cause an innocent person in the shoes of the subject to be fearful, to take some sort of action along the lines of flight. And I just don't see that sort of conduct here. It seems to me that it's more natural to think of this as unprovoked flight. Unless every visit by a police officer to speak to somebody is going to be treated as provocation. That's how it looks to me. How do you respond to that?
Well, of course, the police have every right to try to talk to somebody, and I think that's why it's so important to look at the context here and the flavor of the actual encounter in this case. By Mr. Matthews, they have this kind of nonverbal interaction through their eyes, and then Mr. Matthews actually says something that's smart mouth to the police.
Well, he can't exactly turn it into a provocation when it's not one by reacting the way he did, by reacting verbally the way he did.
I think this court's recent decision in Dozier comes into play here when we talk about the historical context between predominantly minority and underserved communities, and particularly young Black people in America, and the relationship that is had between them and police officers. And law enforcement, they aren't seen to be people that serve and protect, but more so kind of overseers patrolling their neighborhoods, waiting to harass, and whether it's true or not, waiting to harass or subject individuals to indignities. I mean, I don't need to go through the litany of things that have happened over the last few years about, particularly with police officers and Black Americans. But
well, if there were any evidence here of harassment by the officers or bad motivation or anything, that might make a difference. But I don't think we see that here. And my own reaction is that if the officers, if this had occurred in any community in the city, irrespective of the high crime area or not high crime area, low crime area, irrespective of the race or ethnicity of or gender of the individuals involved. If the police see somebody they want to talk to, and as they approach, the person just takes off in headlong flight like that, I have difficulty seeing why that is not reasonable, articulable suspicion
Well,
without more.
well, it's not a
I mean,
matter
there
of,
are innocent explanations, but that the possibility of innocent explanations is not enough to dispel or to show that a suspicion on the part of the police officer is unreasonable or inarticulate.
I think I have a few responses. So first of all, it wasn't just a matter of the police just passing by, again, just noticing, or Mr. Matthews just noticing the police pass by. So this isn't the same as ward law, where you're standing by a building, you have your opaque bag, and a caravan of police pass by, and you bolt.
No, it's not like ward law. I agree with that.
And that's how this court framed it in Miles, in terms of it's not unprovoked to the same extent as it was in Wardlow. My second response is that this court is still taking into account the tension between these communities and people like Mr. Matthews, where there is not necessarily this mutual respect of law enforcement and vice versa. I mean, this is—
Mr. Whitehead, to that point, and I'm sorry to interrupt you in your response, but here Mr. Matthews was with 3 friends. And I guess what strikes me as unique about the case is that the police didn't, as far as we know from the facts before us, focus on the other friends. They focused on Mr. Matthews, which to me signals that it may not have been what you describe as an effort to harass a group of young African Americans in an urban neighborhood. Aren't we able to draw some inferences from the facts that the police were drawn to one person in a group whose actions drew their attention because he stepped away from the group, he grabbed his crotch area, seemed to pull up, and then he ran. Again, if he were by himself, and fearing that he was just being targeted because he was there, that sort of plays more into the issues that you are raising, addressing, reflecting on. I think you referenced our Dozier case, but here he is with the group. They don't harass, at least from the record we have here, everyone in the group to sort of provoke flight. They sort of focus based on some articulated suspicions, if you will, on this one person, and that's Matthews.
Well, I don't think that just by reason of them focusing on Mr. Matthews that eliminates the court's responsibility to take into consideration the historical tension that we have here. I mean, and in fact, if you look at the body worn cam and the rest of the evidence, is that the police weren't necessarily being friendly with Mr. Matthews' friends, as they were kind of wondering why in the world did he get hit by a car in the middle of police car in the middle of the street. They're distraught, and the police are just pushing them away and dismissing any of the concerns that they have. But the point of the selectivity or the targeting of Mr. Matthews, again, the police say, although belatedly, they claim that, oh, we didn't know who this was. We may have seen his face, but we didn't know who it was as we pulled up. But it just so happened that as we were reversing, oh, that's DASEAN Matthews. I mean, there's this flavor of this history and tension between Mr. Matthews and the police through the eye contact and the statement that he makes. It's, what the F do you want? You don't just make that kind of statement if you have no knowledge of, or if there's no kind of history between the two parties. And that is specific to Mr. Matthews. There's no allegation that any of the others made that kind of statement. And yes, he pulls up with a little bit on his groin. Again, there's without any of the other gap fillers or other indicia of you know, a weird, awkward gait. He's not continuously tugging at his crotch. He makes one gesture.
When you think about reasonable articulable suspicion, is it appropriate to take into account the history of these officers with Mr. Matthews? I mean, clearly, if we were at trial, whatever criminal history he might have would have stayed out, you know, propensity evidence, all kinds of good reasons why that plays no role. But when you have police officers who have a history with a particular individual, is that a factor that can be taken into account in determining whether there was reasonable articulable suspicion? That is, they see an individual that they know has a criminal history, let's say, and I don't know what Mr. Matthews' history is, so I'm just assuming this hypothetically. So they pull up and they see someone who has a criminal history of some kind of contraband being possessed, and he makes this crotch adjustment and he separates himself from the group, and then he runs. Is that enough for reasonable articulable suspicion?
I mean, it could be. I mean, this court has taken into consideration specific and particularized evidence, and I don't think it's Henson, but I know there's a case where they knew of an individual who had committed robberies before, but that was specific evidence that was in the suppression hearing, and that was a factor in determining whether or not there was articulable suspicion. Now, here we don't have that case. We don't have that issue where there's a definitive evidence that says, oh, we know Mr. Matthews because he has been a thorn in our side in terms of committing crime, you know, here, there, and everywhere. I mean, there's nothing of that nature. I mean, the only evidence I think that can be divined out of this encounter is that there is at least some prior interaction between Mr. Matthews and the police, that, or at least there's some tension there. And of course, there are more reasons, you know, more innocent people that have tension with the police than there are, you know, police officers knowing I know this guy and I'm going to, you know, I arrest him because he's been involved in crime before. Plenty of people have negative reactions to the police, and the police have, you know, wish they could get something on them perhaps, but it doesn't mean that there is definitively that's evidence that just by knowing somebody and having a negative relationship with them, or a hostile relationship with somebody, that you could take that into consideration in terms of adding to criminal suspicion.
Well, I think I've been listening to this and wondering where this argument is really taking you, because I keep coming back to the question of provocation. Suppose that the police know Mr. Matthews and Mr. Matthews knows them, and the police see him on the street and they say to him, Mr. Matthews, we know you and your background. We suspect you're up to no good. We'd like to come and talk to you. And Mr. Matthews then flees. In your view, is that provocation? Is that a provoked flight? Because you can't really have it both ways in a sense. Well, go ahead.
Well, that's closer to being not provoked flight.
Well, isn't that funny? The police are basically a little bit accusatory toward him, and you're saying that's not provoked flight. But if the police are not accusatory toward him, and they just want to come up to him, and there's been no accusations or anything of the sort, you're saying that is provoked. I have a little trouble with that.
Well, what I'm saying is that, of course, without looking at the rest of the context of whatever considered situation, if the police just walk up and say, you know, there's a mutual understanding, I don't like you and you don't like, you know, I know I've got the goods on you, and that still might not be provoked. I mean, that still might not be Wardlow, because it's not just police passing by. I think
Wardlow was not a one-off. Wardlow may have put a marker down there about unprovoked flight being headlong flight being suspicious, but that doesn't mean that a case has to be on all fours with Wardlow to trigger this.
But I think the court's point is, does the flight indicate consciousness of guilt? And could a reasonable person within the position of Mr. Matthews be potentially fearful or apprehensive about what the police are about to do.
Why is that? The three people he was with didn't feel that way.
Well, we don't know
We don't know how they felt, but they didn't feel
You know, it manifests in different ways, right?
Right.
You know, one person can fly and the others will stand.
Fair enough.
But on the other hand, they're not the ones that told them to go F off, or essentially, what the F do you want? And I think that's an important piece of this case, is that they lock eyes. There's no indication that the police lock eyes with any of the other people on the street. According to them, he says he's separated from them anyway. So there is targeting of Mr. Matthews in this case, and it's similar to Miles, and it's similar to Pridgeon, where just by virtue of shining a light on Mr. Pridgeon and saying, you know, do you have a gun? Mr. Pridgeon breaks out and flees, and that is the first instance that Mr. Pridgeon sees the officers. So in that case, this court said, you know, we're not taking that into account because we understand that reasonable people in that position can be fearful and apprehensive, and, you know, citing to Justice Stevens' concurring and dissenting opinion in Wardlow about, you know, the effect of the police in minority communities. And so I think that's exactly what we have here.
So if this were not a minority community case, would you be able to make the same argument to us that there was provoked flight, that the flight was provoked? I mean, do you want us to write an opinion that makes this case turn on the fact that this is a minority community and that the defendant here was African American?
I mean, this court can, and because of Dozier. I mean, but I also think that it's not necessary. I think what the latest number of cases coming from this court about and emphasizing and re-emphasizing that these aren't check boxes where high crime area plus unprovoked flight equals reasonable articulable suspicion. I mean, this court is, you know, whether it's in Posey, whether it's Chief Judge Blackburn-Rigsby's concurrences in Henson and Johnson, it's all these acknowledgments of what Wardlow means, and that flight isn't necessarily is more ambiguous than what may have been perceived, you know, decades ago. I mean, especially
let's say there was reasonable articulable suspicion to stop your client, to do an investigatory stop. Let's talk about the frisk. Was there reason to pat him down? Because, you know, the police are thinking this man must have some contraband, perhaps. Might be drugs, might be a gun. Did they have enough for the frisk? No. I mean, these are all based, their actions are all based on hunches. Again, if we go back to what the evidence is, with no bulge, no outline of a gun, no call in for criminal activity, no peculiar hand movements, no concealment, and just like Robinson, where you're kind of moving your hands oddly or strangely side to side in front of your jacket, that doesn't mean that he's doing it open and obviously. And I think, again, this court can look to cases like Pridgeon, where, all right, well, we have some information, but let's look deeper and see if we can eliminate all the innocent explanations, or if there's actual evidence that shows that he's armed and dangerous. And there's nothing. I mean, if you look at the character of his flight, I mean, and that's what we looked at in Pridgeon, Miles, he does not, as one might expect, if you have this large object in your crotch, he does not clutch his crotch, or he does not have his arm close to his body or run stiffly, as this court, as Your Honor noted in Pridgeon, in what Pridgeon turned on. He did not drop anything of substantial value and then just and abandon it, as in Pridgeon with the cell phone in a locked building. He did not abandon a bicycle, as this court talked about in Miles, and I believe it was Wilson. But so there was none of those other indicia, and he was completely compliant once he got hit with the car. And there was no other indicia that he was reaching for his crotch area or anywhere else to suggest that he had a weapon. And they never saw
there was no object which they actually saw. There was speculation that he had an object, but again, without any of the gap fillers, without any of the evidence or testimony that could draw that conclusion between his behavior and that he was armed and dangerous, there's simply nothing there to suggest that either the stop and, again, as Your Honor said, particularly the frisk, would have been justified in this case.
All right.
Suppose the police, I'm sorry, go ahead, Chief.
Go ahead, Judge Glickman. I was just reminding Mr. Whitehead that we've taken him over his time.
I see the 4 zeros.
But go ahead, Judge, if you have another question.
Suppose we conclude that the police had reasonable articulable suspicion to think that Mr. Matthews was hiding something of a contraband nature in his crotch. Basically, they would reason just as he was ready to flee, he adjusted his crotch and then he starts running off. And they think they have reasonable articulable suspicion to believe he has something there. The logical possibilities, or the most likely possibilities, I suppose, being either drugs or a weapon, though that there could be other possibilities. Do you think that would justify them, if you accept my premise, which I realize you don't accept, in fact, but if you accept my premise, is that enough to justify a frisk?
No, for the same reasons. Well, because that would still be purely conjecture. Because at that point, all you have is an object, and without any other specificity to suggest that he's armed and dangerous. And I think
you see what I've been wondering about is they have reason to believe he has something in his crotch, and the likelihood is it's either drugs or a gun. They have no way to distinguish between those two possibilities. But I'm just wondering whether the possibility that it's a gun under those circumstances is enough to justify a frisk under a reasonable articulable suspicion standard. The whole notion of reasonable articulable suspicion being that in many, maybe even more than most cases, it'll be wrong. It's only a suspicion and it turns out to be wrong, but it's still a reasonable articulable suspicion. That's what I'm wondering about.
Well, I think it's just that there are too many innocent explanations that we have here in conjunction with, I mean, if you were looking at a reasonable and cautious police officer with training and experience, they would say, and the case law has talked about this, that if the person had a gun in their crotch area and they're running, they wouldn't be running smooth running motion as accepted by the court. There would have been some kind of stiff gait. There would have been some type
Well,
of...
that depends on whether the gun is properly secured or not. What I've been reading these days is that there are ways in which people carry guns, you know, with compression clothing and so forth to ensure that the gun is not shaken around. But
well,
who knows?
I think that's when we start looking for like hyper-technical reasons why the activity or the action is not is criminally suspicious. I mean, but
I have to say, I kept seeing the phrase compression shorts used in the briefs, and I wondered whether that was conveying something to me that I didn't realize. Maybe Judge Glickman has his finger on the reason.
No, not from any personal experience, I should add.
Well, I think where it ends, and I promise, Chief Judge, that I'm done. That still, I think what we look at is common sense, reasonable, and objective. And if we look at the manner, particularly the manner of his flight, if we're consistent with Pridgeon, if we're consistent with Singleton, where it's not just a bulge, it's not just breaking out in flight, it is, okay, let's look at the actual character. It actually dispels, his flight actually dispels the notion, if anything, that he has a weapon or contraband on him. So with that being said, I understand, I hopefully have a couple minutes. We would ask the reverse.
You will reserve your couple minutes for rebuttal, and we'll hear from the police counsel for the government.
Thank you, Your Honor. Good morning. May it please the court, Ann Carroll for the United States. Your Honor, the government submits that based on the trial court's factual findings, the order of denying the motion to suppress should be upheld. Appellant's argument rests entirely on a standard not applicable here, where the evidence is viewed in the light most favorable to appellant rather than to upholding the trial court's ruling. In this case, the trial court fully credited Officer Hyder's testimony. As Officer Hyder testified, they entered this block on routine patrol, a block that he had patrolled daily for several years. And as soon as they entered the block, appellant focused his attention on the officers. And what drew the officers' attention was appellant immediately, by looking into the window of the car, separated himself from his group, which suggested to Officer Hyder that he was about to run, and made that crotch adjustment, which Officer Hyder demonstrated for the trial court. Appellant's arguments that trying to convert this adjustment to a benign, commonplace adjustment is simply not supported by the record.
Ms. Carroll, can I stop you there? One of appellant's arguments is that, as I understood it, is that essentially we should try to look at all of the possible innocent explanations for these various behaviors, the crotch adjustment, the separation from the group, I'm throwing in separation from the group, but I think appellant's counsel said that we should focus on the innocent explanations for the crotch adjustment and the flight. And is that what we're required to do in our review on appeal of this? Look for the possible innocent explanations, or how would you characterize our role here?
Well, as
certain findings.
I'm sorry, Your Honor. As the Supreme Court has repeatedly said, there may be innocent explanations for any one isolated factor, but the totality of the circumstances analysis has to look at the combination of factors in light of the officer's training and experience. This officer had been trained to detect behavior consistent with one concealing a gun. The officer was with crime suppression and gun recovery unit that was targeting violent crime and gun recovery. And this officer testified that they had recovered guns from crotch areas on such a frequent occasion that they indeed had a protocol, that is to ask questions so that they can safely remove a weapon without it accidentally discharging, injuring either the officer or the suspect. So this was not a benign adjustment under the circumstances that the trial court found. And with respect to the demonstration, I'd cite Arvizu, the Supreme Court opinion, particularly where there has been a demonstration, the effort by appellant to try and recharacterize what the trial court found based on actually seeing what the officer saw. Under those circumstances, that type of finding by the trial court is entitled to the greatest deference, because we're not in a position, based on viewing a cold record, to recreate what the trial court observed. And based on that demonstration, Judge Burke found that it was reasonable that the police officer believed there was contraband secreted in appellant's crotch, that the action that he observed was pulling an object and securing that object before and in anticipation of running, which appellant did. That headlong flight, so much so that he couldn't stop himself before running into the reversing police car, led Officer Hyder to further suspect it was a weapon. And that was why Officer Hyder, as is visible from the body-worn camera, immediately told Officer Wilson to frisk appellant, because he believed, as he testified, at that point, based on the totality of those circumstances, it was a weapon. So based on this court's past cases, as well as the facts found by Judge Burke, the trial's determination, the order of denying the suppression should be affirmed.
I'm not remembering the testimony. What was it about the inability to stop himself before running into the car that contributed to the suspicion that the contraband was a weapon as opposed to drugs?
I don't think it was that explicit, and I'm arguing based on the reasonable inference. What Officer Hyder said when he first saw it, he described it as contraband, an item. And then he's testified after appellant ran into the car, he believed it was a firearm. So there was, he did testify he believed it a firearm. It was later. I would argue this does tie into Wardlow's language that headlong flight is the consummate act of evasion. And while it may not be evidence of consciousness of guilt, and I'm paraphrasing, it is certainly suggestive of such. And in this case, it was the manner in which he fled, which Judge Burke found was he just out sprinted. He was very fast, and he ran so fast that when he ran into the street in order to evade Officer Wilson, who had moved onto the sidewalk to follow him, he couldn't stop himself. My argument based on is based on a reasonable inference from the essential progression that appellant at first saw the officers, walked quickly away from his friends, his companions, made the adjustment, and then began running and ran several directions and into oncoming traffic, as it were. My argument is that there's a reasonable inference based on those facts that it was his ferocity, if you will, of his desire to escape police that formed an additional indicia that this was a firearm. But regardless, as Judge Burke found, the officer believed based on watching the adjustment, and Judge Burke found based on watching the adjustment demonstrated for him, that it was either drugs or a gun that was secreted in appellant's crotch area. And based on the ambiguity, as this court and the Supreme Court has repeatedly held, the officer was not required to wait and investigate further before resolving that ambiguity when one of those objects was a dangerous object that could be used against him.
How do you respond? Go ahead, Chief.
The dangerousness, wasn't that mitigated by the fact that appellant was handcuffed on the ground when the officer rolled him over to search his crotch area for the gun? So it seems to me that if it was a gun and dangerousness was the concern, that was mitigated because he was on the ground and handcuffed and couldn't discharge the weapon. And if it was drugs, then that would also mitigate the need for the frisk for weapons and safety.
Right. Well, and I would submit that when you have a suspect who is handcuffed, I think many of this court's cases have recognized that there could be a protective pat down even when somebody is handcuffed. Certainly, if the appellant was not under arrest at that point and would not have been placed under arrest at that point, but the officers weren't required to, after observing everything that they had, not investigate further. And in order to investigate further, there was a suspicion of being a weapon, and they went directly to that location where they saw appellant make that gesture, which led them to believe it was a gun or narcotics. Did a protective pat down. This was not an invasive search. This was a protective pat down, and Officer Wilson immediately announced it's a gun. So I don't think that these cases have ever held that once an appellant is in handcuffs, that there is no longer a need to do the protective pat down to recover the potential weapon that may be on the street.
Wardlow speaks of unprovoked flight. Was the flight here provoked or unprovoked?
It was unprovoked, Your Honor.
And you've heard Mr. Whitehead's argument that it was provoked, and he cites cases like Miles. How do you define provoked or unprovoked?
I agree.
Why was this one rather than the other?
I agree with Your Honor's description that certainly an innocent person would have to feel fear from the approach in order to call the approach provoked.
Now, do you have support for that proposition? Other than the fact that I said it, a few moments ago.
I cite Your Honor as high authority, so, but more than that, the only case.
We'll have a lot of persuading to do for my colleagues if that's going to be your argument.
No, I don't believe that. The only case that appellant cites is Miles. And even in Miles, which this court described as a very close case, the provocation was this, that one police officer was following behind the suspect. The other police officer drove his car onto the sidewalk to block the suspect's path. And then that officer got out and ordered the suspect to stop. We do not have any of those factors here. We do not have appellant's path being blocked. We do not have the car being driven up onto the sidewalk. We don't even have the officer directing appellant to do anything. Appellant says, you didn't even say anything to him. The officer never had the opportunity. Before the officer could get out of the car, appellant had engaged in headlong flight. And as the evidence from the body-worn camera and the testimony is, as soon as the officer opened his door, appellant was running, because as soon as the officer opened his door, he was chasing after appellant. So there's no case that has ever held, as far as I'm aware, and certainly none that appellant has cited, that has held that these facts constitute provocation.
Right. Anything further? Either questions from the panel or any further comments, Ms. Carroll?
If there are no further questions, we'd rest on our brief and ask the court to affirm the trial court's order denying the motion to suppress. Thank you very much, Your Honors.
All right, thank you. Mr. Whitehead, I believe you reserved a couple of minutes for rebuttal.
Yes, thank you. I do want to clarify a couple of things. I believe the government mentions this statement about Officer Hyder, the suggestion that Mr. Matthews, by being hit by the car, that was further indicia of being armed and dangerous, but that's nowhere in the record. And I don't think that inference could come from the record. We also have the flight. And I think what's important here is whether or not the activity of the police in the circumstances remove any kind of guilty meaning from the flight itself. And so where we have this initial interaction between Mr. Matthews and the police officers, and one in which somebody in his position would reasonably believe that, okay, well, after I just said what I said, and looked at the police officers, if they stop in the middle of the street and start going in reverse, they don't go all the way around the block, and again, they don't park, but they stop in the middle of the street and go in reverse and start getting out of the car in the street, that would cause a person in that position, a reasonable person, to fear and feel apprehensive. And that's kind of the point, and that's the point of Miles, and that's the point of whether or not something is provoked or unprovoked. And here, that's the situation that we have. A person in his position being targeted, being selected by the police as somebody that they're going to confront, would feel fear and apprehension to the point where the flight is not meaningful in a consciousness of guilt sense. And there was one other factual position about Judge Burke's findings, and he never said that the flight was unprovoked in the first place. He did say, and we admit that he ran and it was headlong, but the whole point is whether or not it was unprovoked, and certainly the trial judge didn't resolve that. And the fact that the trial judge kind of reflexively believed the conclusory statements of Officer Hyder to suggest that there was contraband on his person, this court has time and time again said that you can't just have judicial acquiescence to an officer's subjective beliefs. That's what the court's role is to look at the objective criteria and the reasonable facts to determine whether or not it was actually objective and particularized. And lastly,
So are you suggesting that if we had concerns about whether this was provoked or unprovoked flight, that a remand to the trial court would be necessary?
No. I mean, I think it's just as a matter of law, this is that's not a factual matter. This is a legal matter, and this court would resolve that issue as to the not unprovoked nature of Mr. Matthews' flight. And I see my time is up. I just wanted to quickly say that the officers in this case, they were part of the crime suppression unit. They were part of,
Is unprovoked flight a mixed question of law and fact?
Well, I think at the end of it, of course, that there are facts that are involved, and I think the court found that he fled from the police. And in terms of that, there was the timing of the circumstances that came before that flight. That's already been determined, but this court has to make the legal determination as to whether or not that flight was indicative of consciousness of guilt. And while the trial court did find that it was indicative of consciousness of guilt, but this court's role now would be to determine whether or not it actually was, and whether or not it was not unprovoked, whether or not a reasonable person in that position would be fearful and apprehensive about, what that nature of the interaction is about to be. It's not going to be a friendly one. So last, I did want to say that this court in Robertson did warn trial courts and the court about hyper vigilant officers, and again, believing officers, particularly where their specific patrol is proactive. Like a case like this, crime suppression unit, there's been no call or no report for any crimes, and that rove neighborhoods and seek out crime. It's a self-fulfilling prophecy. So this court has to be extra careful about the subjective beliefs about these officers that are in these positions in such a kind of proactive, hypervigilant policing. But with that said, I appreciate the extra time, and I would ask that this court reverse conviction.
Can I ask just one question, Chief?
Absolutely.
Here's my question. Our court sees these cases, of course, only when it turns out that the police officer's suspicion turned up something. A gun is found, drugs are found. Does anyone, to your knowledge, have any records on how often police in a situation such as the one here stop a person and handcuff him and frisk him and find nothing or something equivalent? I mean, I just don't know. The impression you get when you keep seeing cases of the police stopping people and sure enough, finding the gun or finding the drugs is that the rationale that they offer, I saw a crotch adjustment, I saw running with a stiff arm, I saw the defendant doing something else like that told me, in my experience as a police officer, that the defendant was secreting some kind of contraband. And then in all the cases we see, that turns out to be correct. Is there a record somewhere of the opposite? I have to say, I don't know how there would be, because I don't know who would report these things. But to your knowledge, is there? How would we check on this if we wanted to?
Well, I guess we would have to ask MPD, who I assume won't take records about all the people that they search and seize without justification. But I think that's the beauty of the Fourth Amendment, that the ends don't justify the means, and also that there has to be a litany of way more people than even though the court says, oh, we only see these cases when somebody actually had a gun or a weapon or drugs on them. This is still just anecdotal. I mean, it's still just a handful compared to what goes on. I mean, and that's the reason why this court had to make statements that it did in Dozier. That's the reason why, this court had to make the finding or have the footnote in Pridgeon about the flight. This is the reason why, Chief Judge, you had to have these additional concurrences in Johnson and Henson. It's because we've had this history of suppressed and repressed people who have had these instances take place time and time again over decades and centuries that haven't been reported. So again, that's the beauty of the Fourth Amendment, that the ends don't justify the means in this case, because for every one DASEAN Matthews, there's hundreds and thousands of others that are in these communities. And that's why we don't take high crime area into consideration is one may think back in the past, is because they have to suffer these indignities on a daily basis. And we don't want to get to the point where, we luckily in the 90s, early 90s, we had a video camera that showed, luckily or not, Rodney King being severely beaten. And then those officers went scot-free. That was with the camcorder on your shoulder. What would have been the scenario had we had body-worn camera, had we had cell phones back then to more keep police officers in check? So I would say, even without hard statistics in my brain or right here on my hands, I think it's safe to say that these things happen in our communities, unfortunately, and it's this court's role to keep the police in check and to deter them from making these types of decisions without reasonable, particularized suspicion. Thank you. We would ask to reverse.
Thank you. I'd like to thank both counsel for your briefs and arguments today, and the case will be taken under advisement. And you're free to exit our virtual courtroom at this time.
Thank you. Have a great day.
Thank you, Your Honor. Have a good day.
Thank you. All right. Good morning. This is our second case for this morning. LAFFETTE Copeland versus United States. Counsel, are you ready to proceed?
Yes, Your Honor. Good morning, Your Honors, and may it please the court. Adrian Madsen on behalf of appellant LAFFETTE Copeland. I'd like to reserve 3 minutes for rebuttal. On August 21st of 2018, an incident happened in front of 441 4th Street Northwest, very close to the court here, directly underneath a CCTV camera located near 4th and East Streets Northwest. Officers from 2 law enforcement agencies responded, took witness statements, and canvassed the area. Officers from 1 responding agency, the DC Protective Services Division, operated and maintained cameras on the same building. An officer from the PSD, the Protective Services Division, wrote a report, took received notes from an MPD officer, and the case was later assigned for investigation to an MPD detective. No arrest was made on the scene. The detective that was assigned continued as the assigned detective on the case until at least a warrant was later issued for Ms. Copeland's arrest. When later seeking that warrant, the MPD detective assigned incorporated as the first paragraph in its entirety the public incident report that had been authored by one of the Protective Services Division officers. This court's case law unequivocally imposed a duty upon officers, members of the prosecution team, and therefore the government, to preserve footage from that camera, footage that would have shown the events leading up to the incident in the case, the incident itself, and the events immediately after the incident. If a picture is worth 1,000 words, and the failure to produce Jenks statements constituting far less than 1,000 words rightfully often warrants reversal, video of the incident itself and the events before and after it surely warrants the same. As this court has repeatedly held, the duty of preservation under Rule 16 is antecedent to the government's obligation to disclose these materials upon a defense request.
Well, Mr. Hasden, if we were to agree with you that the PSD video in particular was within the possession and control of the government and should have been provided, what's the remedy you seek? The trial judge never reached the issue of whether or not there was bad faith, and a bad faith determination would be necessary in order for us to dismiss based on a Rule 16 violation. So what's the remedy that you would be seeking?
Your Honor, the remedy that Ms. Copeland seeks is a reversal and remand to the trial court for directing the trial court to hold an evidentiary hearing about what the appropriate sanction would be. As the court is aware from the record in this case, Ms. Copeland moved for sanctions, in particular dismissal. Without a hearing, the trial court denied that motion based on its finding that which Ms. Copeland submits was error, based on its finding that, in particular, the PSD footage was not in the government's possession, custody, or control. In the moving papers below and in this court, the government has never taken the position that the footage from this camera would not have captured the incident. That is, the government has taken the position that Ms. Copeland has not essentially shown a negative, shown what would have been captured by the footage. But the remedy that Ms. Copeland seeks is reversal and remand with directions to the trial court to hold an evidentiary hearing on what the appropriate sanction would be. Ms. Copeland submits that based on as below that there was bad faith, but that is a finding for the trial that the trial court needs to make after having a hearing in the first instance.
What factual issues would the trial court be looking to resolve through an evidentiary hearing?
Well, Your Honor, in the first instance, as I mentioned, that the court would be applying the three factors, of course, that are relevant in determining what sanction to impose for Rule 16 violation. Although this court has at times articulated them differently, the degree of negligence or bad faith involved, the importance of the evidence lost, and the evidence of guilt adduced at trial in fashioning an appropriate sanction. With respect to, if Your Honor's question is with respect to factual issues about the video itself, again, Ms. Copeland below proffered, I think quite reasonably and quite logically, based on the positioning of the camera, that this would, and the testimony that later came out at trial about where this occurred, that this camera footage from this camera would have captured the incident itself. So there are not.
Now, I'm not sure that one is in dispute at all. I don't believe the government has said so. Really, the focus of my question was the whole issue of negligence, because I mean, assuming that the video cameras were both in the possession, custody, and control of the government, I don't think we've gotten any argument that not preserving them was not negligent. It seems that it was, but on the record we have the defendant was not on the scene, and there was no claim of self-defense at the time. All there was the complainant who described what happened and the eyewitnesses who described what they saw. And there was no apparent reason for anyone to think that the video would be exculpatory. I'm just wanting you to focus on whether it was somehow an abuse of discretion not to hold an evidentiary. Well, the court having found no possession, custody, and control, it would not have held a hearing. But I'm trying to figure out whether there really is a basis for an evidentiary hearing when at least I don't see a particular basis for thinking that this was anything more than pure negligence. What fact would bear on that? What do you think a hearing might show as to that issue, not as to the what might the video show issue?
Understood, Your Honor. I would point to two things. First, Your Honor, that Ms. Copeland averred below that in light of this court's decisions regarding the obligation, in particular, to preserve video evidence, that the policy itself of having a routine destruction after 30 days, and I'll note that there was no testimony because there was no hearing, but there was no proffer from the government regarding the PSD footage about whether and when, about when it was overwritten and why. That is simply that there was no footage to produce. That is, one factual issue that a hearing would.
Well, but there was no one called into question the government claim that there was a 30-day override policy. In other words, there needs to be a factual issue to resolve, does there not?
Your Honor, the 30-day override policy that the government referenced was with respect to the United States Attorney's Office footage, not with respect to the PSD footage. So there was no proffer below regarding when that footage was destroyed. And the second thing, Your Honor, that is that that a hearing could elucidate is in particular that, of course, brief indulgence, the joys of doing oral argument at home. So the second thing, Your Honor, that a hearing on the issue could resolve is whether why the footage was preserved. Again, it is supposition at this point to say that the PSD footage was simply overwritten. It could have been actively deleted, right? But we simply don't know. The government didn't put any evidence in the record regarding that below, and we don't know. And so in determining the degree of negligence or bad faith involved, both of those things could be further tested at a hearing on the motion.
Now, I would have thought that at a hearing, the the Protective Service Division officers who were involved in this case would be put on the stand, and they would be asked such questions as, did you know there was a camera there? Did you know that the camera was focused on that location? Did you bother to look to see whether there was video footage? Why or why not? If you knew there was video footage, why didn't you preserve it? Did anybody tell you not to preserve it? Did you discuss preserving it with anybody? I mean, there's, a whole litany of questions that could be asked to determine, first of all, to nail down that there was in fact a camera that was on that day and that it was taking video footage, which everybody's been assuming, but we don't actually know. But beyond that, there'd be a whole litany of questions to determine whether there was bad faith involved. Maybe the officer would have said, well, I knew there was footage, but I thought we had enough evidence, and I figured I wasn't going to bestir myself to preserve it. Or my supervisors told me, don't, it's too much trouble. Or who knows what they said. That's the purpose of the hearing, to find out what happened and why. And then, if it turns out that there really was footage and it was not preserved, then the court could consider all those factors in determining the degree of culpability, if any, and an appropriate sanction. It seems obvious to me there has to be a hearing in which you ask these people these questions.
Yes, Your Honor, and I agree completely with Your Honor's point, and in fact, very much expected as trial counsel in this case for that to occur below, and was very surprised by the fact that that did not occur. But I completely agree with Your Honor. Turning to the issue.
So I take it we could remand for a hearing on this subject and leave open the question of whether the conviction actually has to be reversed. It would depend on the outcome of the hearing, right?
Well, Your Honor, I'll note that a difference between this case and Askew, a case in which the court did the same, that is, where there was a record remand for additional factual findings, is that in that case, of course, the court found possession, but found that no sanction was appropriate, and this court found that was error. But here, again, the government has not contested what was at issue in Askew. That is what would have been captured by this footage. I understand Your Honor's point and agree.
The government doesn't know either. As far as I can tell, the government can't really say that the camera was even on that day. There's no investigation, nothing in the record that tells us much of anything, right?
I agree that what is in the record comes from Ms. Copeland by the location of the camera. That is that the camera is operated by the PSD, and then looking at the trial testimony of where the events occurred. Yes.
Let me ask you now regarding the threshold question of whether the Protective Service Division officers were part of the prosecution team in this case. It's my understanding, correct me if I am wrong, that the Protective Service Division officers are special police officers with the power to arrest, investigate crimes, and so on and so forth. just like regular police officers in their area of responsibility. Is that correct?
Your Honor, the code is somewhat ambiguous. They certainly are at least special police officers. I'll note that and this evidence is in the record attached to, I believe it's the record index at 15 and 18, Ms. Copeland's motion for sanctions and the reply to the government opposition, that certainly the uniforms that the officers are wearing don't announce them as special police, but simply police with arrest powers, albeit in a limited jurisdiction. So they are
And in this very case, is it correct that they investigated the assault and interviewed, or I say they, maybe it was one officer, investigated the assault and interviewed the witnesses and wrote reports?
Yes, Your Honor.
And that information was turned over to the detective or to whoever it was from the Metropolitan Police Department who was involved?
Yes, Your Honor.
Okay. You know, you think that's enough to make them part of the prosecution team for purposes of this case?
I do, Your Honor, and I'll note that this court has never held, and the government cites to no case, and this court has never held in a Rule 16 case where officers from a law enforcement agency responded to the scene, interviewed witnesses, and wrote reports that they were not part of the prosecution team for Rule 16. I know in the briefs in this case,
I assume, by the way, there was never a grand jury proceeding in this case, right? Because it's all pure misdemeanor, right?
That I will say, Your Honor, if there was a grand jury, it was never never returned an indictment and was never made known to Ms. Copeland. Yes, but this court has never held where officers from a law enforcement agency responded and played that role, that they were not part of the prosecution team. I know in the briefs that both Ms. Copeland and the government addressed the import of Myers and Wilson, but I'll note, Your Honor, that in those cases, that the only reason the court was going through that analysis is because WMATA, the entity that was at issue in both of those cases, is the creation of an interstate compact. Here, what we're dealing with is a law enforcement agency that is part of the district government. So there's no need to sort of go through this governmental versus proprietary analysis. That is, this is a law enforcement agency, just like the MPD that responded to the scene, investigated. The MPD officer who did respond, in fact, turned his notes over to the officers from the Protective Services Division, who then authored these reports. And again, the affidavit in support of the warrant, the entire first paragraph that establishes, according, the allegation of where the incident occurred, when it occurred, all comes from this report authored by the PSD. So to hold otherwise would sort of incentivize this, passing off of information to another agency and then washing your hands of the allegation. So that this is not a case like Myers, as the government concedes, where the PSD was involved in this case. And in Myers, of course, this court was focused on the fact that the transit police were never involved at any time, and that's just simply not the case here. And I think, as laid out in the briefs, that the PSD was plainly a member of the in this case. If there are not further questions, I see that my time is up, so I'd like to reserve the additional time for rebuttal.
All right, thank you. We'll hear from counsel for appellee, the government.
Thank you. May it please the court, Mark Hobel for the United States. The trial court did not abuse its discretion when it denied the defendant's motion to dismiss the information. I want to highlight 2 points today. The first is the lack of any plausibly alleged bad faith on the part of law enforcement, which—
Well, but doesn't that come after there's a determination about whether or not this material was within the possession and control of the government, which is, I guess, the sequencing here is important to me, I guess. And I think it was error on the part of the trial court to conclude that this PSD, Protective Services Division, somehow wasn't acting as, or in fact, an arm of the government or part of the investigation. Can you speak to that first? Because it seems to me it's hard to get to bad faith.
Mhm.
I think it flips the analysis. Maybe that's just semantics to first jump to whether or not it was bad faith.
Right. On the underlying Rule 16 issue, this, we acknowledge this is a hard, fact-intensive question whether PSD was a part of the prosecution team.
Is it really a hard question here, given their own mission as defined, as they define it, to help federal and District of Columbia government and MPD? I think that's actually a part of their mission statement with investigations. And even if that weren't in their mission statement, when we look at what they actually did here, it seems to make that a fairly straightforward issue, in my view.
Right. No, and we acknowledge that there are facts here that make this harder for the government than say the Myers case. But we've tried to put our best arguments in the brief for why they're not prosecution team. But even assuming that there was Rule 16 error, the only sanction that the defendant actually sought was dismissal of the information. Under this court's clear precedence, that required bad faith. The defendant didn't even plausibly allege bad faith. The defendant relied solely on the failure to preserve video footage, which at most is careless and possibly negligent, but under this court's precedence does not justify dismissal. Youngblood controls in those instances, and that's not bad faith.
Why do you say at most it is carelessness or negligence? It seems to me that if officers know that there is a video there showing the truth about what happened here and willfully let it get destroyed, that might be viewed as, and knowing as well, or they should know, that they have an obligation to preserve that information for discovery. Are you so sure that a judge couldn't find bad faith under those circumstances? It strikes me that a judge could say, this was paradigmatically bad faith. You just didn't care about your obligations. You knew about them. You didn't care about them. And you let this evidence be destroyed.
I
It
think
sounds more than just negligent.
I think the key word that was in your, I guess I want to say hypothetical, Judge Glickman, that I want to focus on is willfulness, because willfulness is what's not present here.
How do you know?
Because
How do you know it's not present?
it wasn't even alleged by the defendant, and I would just direct the court to the defendant's motion to dismiss at pages of the appendix, pages 20 through, let's say, 24, and specifically at page 24. I'm sorry, specifically at page 2 of their appendix. These were the facts alleged by the defendant. The combination of these facts, Ms. Copeland's timely specific government's inaction, the MPD's failure to comply with applicable policy and regulations, that counsel for Ms. Copeland did not learn of the allegations until nearly 1 year after the alleged offense, and earlier decisions of our Court of Appeals expressly putting the government on notice constitute bad faith. Those were the facts alleged, and that just as a
Wait, you forgot the other fact, which is that the thing was destroyed.
Well, it was.
I mean, they asked for an evidentiary hearing in their pleadings, and it's so obvious to me that an evidentiary hearing would be necessary to determine what happened and the question of culpability. I don't know why the government is resisting that, frankly.
Well, I think that the second point that I wanted to make here is harmlessness, and that is as the defendant has indicated, the choice of a sanction. What in reviewing the choice of a sanction, this court also looks at the evidence adduced at trial. To the extent that there was a Rule 16 error here, it was harmless because you have overwhelming evidence of the defendant's guilt. You had two neutral, credible eyewitnesses, fully credited, who completely corroborated the victim here and completely contradicted the defendant's self-serving self-defense narrative.
Well, I want to ask you about that, but let me first go back to the question of why the PSD video was not preserved. What I was recollecting from the briefs, and this is the reason for my questions about what will come out of hearing, was that in opposing the motion for sanctions for dismissal, the government represented that per PSD, the video had, like the USAO video, been destroyed pursuant to a 30-day override policy. Is that not correct?
That's correct, Your Honor, and thank you.
Right, and I guess my question on that is, did the defendant push back on that? I mean, was there a suggestion that there was some question about whether there was a PSD 30-day override policy?
No, I think here the parties essentially proceeded by proffer, and there was no material factual dispute that there was that there were override. There was a 30-day override policy at PSD, and that's the reason that the video was no longer available.
Now, going to your next point, I wanted to ask you about this, about the eyewitness testimony, because the trial court seemed to think that there was a blatant contradiction between the testimony of the defendant and the testimony of these eyewitnesses. The defendant testifying that that the complainant turned around to face her and was striking at her with a pointed umbrella, and the eyewitnesses saying no, they saw the defendant following the complainant, and the complainant had her back to the defendant. And the trial court seemed to say that those two things could not be squared. They were blatantly contradictory. And I looked at the testimony several times to try to discern whether that is so, because because they were walking in opposite directions, the eyewitnesses and the other two individuals here. And when they saw the defendant and the complainant walk by, the defendant was behind the complainant, and the complainant had her back to the defendant. But they then presumably continued on their way, the eyewitnesses did, walking in their opposite direction. So I don't think they testified that they kept their eyes on the defendant and the complainant at every moment after they first saw them. They turned back around in time to see the defendant hitting the complainant. But what I'm wondering is, could there have been a second or a few seconds when the complainant turned around, faced the defendant, and tried to strike with the umbrella? In other words, what I'm getting at is, was there really blatant contradiction between those two accounts? What do you have to say about that?
There was, and I think that Your Honor, there were two eyewitnesses, and I think Your Honor is describing much closer to the testimony of the second, Charlia Robinson. The first eyewitness, however, Tamara Vines, she testified that she saw 5 to 10 seconds before the defendant actually assaulted the victim, and what she saw is the defendant and another person following behind the victim, and the victim, walking, not facing. I believe she testified that the victim was not facing the defendants, but I think Your Honor would want to look at the transcript for that. But she testified that what Ms. Vines testified, that she actually saw the 5 to 10 seconds, the crucial 5 to 10 seconds preceding the assault, and she didn't see anything like what the defendant said happened, which is that the complainant was, walking backwards and shouting all these want to be careful how I characterize this, saying hostile things and swinging an umbrella and hitting the defendant. She didn't see any of that. She just saw the defendant come up behind the victim and hit her, which corroborates the victim's account. And, you know, Miss Robinson too, although she was a little closer to the way Your Honor put it, where she walked past them and then turned, you know, the sequence of events that the defendant described happening would have drawn her attention. But what drew her attention is what actually happened, which is that the defendant came up behind the victim and hit her. So I think that, but specifically, I think Tamara Vine's testimony, the first eyewitness, fully corroborates the victim. And again, the Judge Oken found that she was completely credible, unbiased, just somebody who was going out to lunch when she could not impeached, just somebody who was going out to lunch and saw what happened.
Mr. Hobel, could I take you briefly one more time back to the issue of the videotapes and whether or not the government had a duty to preserve those PSD tapes, and just ask you, you talk about the 30-day override provision and that there was not really a challenge to that before the trial court, or a specific allegation made at that time when appellant was requesting the materials and or a hearing. But I guess I wonder if you could talk a little bit about how you view the government's duty under our Robinson case to have anticipated that this video tape information was, number one, there, available, and material, and therefore triggered the government's duty to preserve it prior to trial.
Sure. And, you know, I think the major distinction here with Robinson is that Robinson involves a really blatant situation where an MPD officer is just listening to a call that he knows is recorded by the jail. I think here, you know, the level of, I guess, you know, it would be best practices, and it's best practices for officers to check building surveillance, check CCTV, but you're talking about a camera that's up on the side of a building and the action is happening down here. So, you know, it would have been, I think it would have benefited everybody, and it would have benefited us in our investigation if the officers had looked up and said, gee, you know what, we should make sure that we get the footage from that camera. But I don't think there's anything as obvious and striking as in Robinson that should have put them on such clear notice. Again, you know, the standard here is not perfection. And this may not have been best practices. This may have been careless. This may even have been negligent. But the failure under these circumstances is not bad faith. And Robinson didn't find bad faith either. Robinson specifically did not find bad faith. So, and this is less egregious, certainly, than Robinson.
If at a hearing, the court had agreed with you and said it wasn't bad faith, you're speculating when you say that, I think. But if the court had agreed with you, then the issue would have been, well, all right, since there's no bad faith, I'm not going to dismiss this prosecution. But a sanction is in order. And there's a range of sanctions that the court could have imposed. And I mean, the notion that without the video, the evidence is pretty bad for the defense is simply an argument for why it's important to honor the defense right to, under Rule 16, to obtain the discovery of material things like a video of the incident. I just don't, I mean, we've had more recent cases than Robinson in which a video, for example, at a police station, when the person who's been arrested and the crime is over with and so on and so forth is brought to the station. We held, well, you know, those things are destroyed every 30 days. But in this case, somebody should have said, wait a minute, let's not destroy this. because we have an obligation to turn it over. I don't hear you arguing that those cases were all wrongly decided or that they're distinguishable.
Sure. So I think on the point of bad faith and whether dismissal was warranted, they're actually good for us. Kuntz, Askew, these
Well,
are.
they had a hearing. If you have a hearing and you can identify that, it was really negligent, that's nice. But we haven't had a hearing and we don't know that it was merely negligent in point of fact.
Right. Well, I think you'd have to, in order to have a hearing, first of all, all
you have to have for a hearing is a proffer that the evidence was in the possession of the government and it was not turned over, it was destroyed. That triggers a hearing to determine, more fully what happened and why it happened. That's the way I look at it. Unless there's agreement on which there isn't in this case, as to all those material facts.
I guess I'd respectfully submit, Your Honor, that there were proffers from both the defense and the government in this case, which established agreement about certain undisputed facts. In other words, there was not a dispute as to why the basic operative facts here, which is that there was a camera. The footage was not preserved. It was overwritten after 30 days. And the basis for the allegation of bad faith was essentially those facts. So
no, the material fact in dispute, you've left out the one fact that's most material, which is why is it that police officers who presumably know their obligations under Rule 16 didn't preserve this video? There's a range of possible reasons. But that's the material fact, and that should have been, it seems to me, determined. And the only way to determine it, I think, would have been an evidentiary hearing.
Right, but in order to show bad faith, what bad faith means under this court's precedence is a willful, specific destruction or loss of evidence in order to deprive the defendant of the use of that material or the examination of that material.
So maybe they couldn't have shown bad faith at a hearing, but they would have shown nonetheless pretty culpable negligence. And they would have said, okay, Judge, we thought we could show bad faith. We didn't show bad faith at the hearing, but we did show a lot. So we would like a sanction.
Okay, and so then I think we get back to harmlessness, because assuming we're taught what is this, the defendant has not even suggested below.
How did the umbrella get broken?
What other sanctions would have been? What other available appropriate sanction?
Well, you could strike witness testimony. You could strike witness testimony. How did the umbrella get broken, for example? Well, we don't really have a good answer to that. Your Honor, maybe if we had the video, we would have had an answer, and maybe it would have been favorable to us. Now, there are a lot of sanctions that really can sting and have an impact on the trial that the judge could have considered, depending on what the evidence at the hearing would have been.
Right. Well, I think certainly one possible sanction would have been the argument that there is now a factual basis for a Greer-type argument, that this was a sloppy investigation. There was a failure to investigate. And in fact, the defense opened on that at the trial, said there was in their opening statement said there was a camera and the police didn't go get it. And it would have shown what happened. And this was a sloppy investigation. And then for whatever reason, the defense chose not to present with it. We didn't object to that. And then the defense chose not to present any evidence on that point. And we don't know why that was, but there was, I think, again, going back to harmlessness, there was a range of arguments they could have made on this factual predicate, and they seem to have attempted to have made, and then just kind of abandoned it. So I think, again, from our perspective, even if you assume that there was a Rule 16 violation here and that they're correct about prosecution,
you don't concede that?
We've made our arguments in the brief, and we acknowledge it's a hard question. But
do you acknowledge that your arguments are not valid?
No, we don't acknowledge that our arguments are not valid, Your Honor. But we know that's a close question. We think that the court doesn't even need to reach it here. Or, if it does, it's not dispositive, because they're not entitled, they weren't entitled to dismissal. They haven't even alleged bad faith. And they have not shown, and we've shown that this is harmless based on the strong testimony of these eyewitnesses, which show that if anything, if we'd had the video, it would have been even more powerful evidence of guilt. So I see my time is up. If there are no further questions, we'd ask this court to affirm.
All right, Mr. Hobel. Mr. Maz, you reserved a couple minutes for rebuttal.
Yes, Your Honor. I'd first like to return to the Judge Glickman's question and Judge Thompson's questions regarding whether the PSD footage in particular was, whether the government represented below that it was a product of this 30-day overwrite footage. I will note, and I want to correct a statement that I made before, that on pages 8 to 9 of the government's opposition below, which is 8 to 15, the government in a sentence that is not attributed to any investigation, unlike the statements regarding the U.S. Attorney's Office, does say that the cameras operate in 30-day overwrite mode. When laying out from the government's view, the relevant factual background on pages 1 to 2 of the motion, which is again in the record at 15, they don't do so and specifically address the United States Attorney's Office and what the MPD did, but not this. So I will note that it's unclear, but whether there's no record evidence that the government communicated with the PSD about the footage, but they do make that representation. So I do want to correct that statement. Regarding harm, Your Honor, that is, Judge Thompson, you asked questions regarding whether there was a contradiction between whether there was a stark contradiction between the testimony of Ms. Copeland and the testimony of the eyewitnesses. I would just direct Your Honors to page 37 of the transcript from November 25th. That is where Ms. Vines is testifying on redirect. And I'll also note that there is a question to which an objection was sustained. And of course, the answer to that is not here. And Ms. Vines does not say, and this is on redirect, that she saw, that she kept her eyes on Ms. Copeland after seeing Ms. Copeland allegedly walk by her with these other persons. She says, and there's a question that is, and again, this is on redirect, and also the defendant walked by and then assaulted the victim. Answer correct. And there's a beginning of a question. So in fact, and the answer is, but I didn't see anything that led up to that. And that is the answer on redirect. So I don't think there is testimony, or at least unimpeached testimony, that the complainant, I'm sorry, that the eyewitnesses saw everything that led up to that time. In terms of permissible sanctions, Judge Glickman, you have correctly identified that a permissible sanction would have been to strike their testimony, and where the trial court in this case, in its factual findings, stated that if it had just been the testimony of Ms. Copeland and the complainant, it probably would have had a reasonable doubt. Those are the words of the trial court, and so I don't think the government can show harmlessness here. And finally, just with respect to the government's argument regarding Greer, of course, is not a sanction. Greer is a permissible argument in any case, distinct, of course, from a missing evidence or missing witness instruction. So there would have been no basis for the government to object to that. And I see that my time is now up, and for the reasons stated and in the brief, we would request that the court reverse the trial court and remand for an evidentiary hearing.
All right, thank you. We'd like to thank both counsel for your briefs and arguments today. And you're free at this time to exit our virtual courtroom, and that concludes our matters for today.
Thank you, Your Honors.
This court is now adjourned.